Director for ADR at FEMA, the Federal Emergency Management Agency. I'm also Chair of the subsection on workplace conflict management under the Interagency ADR Working Group. And on behalf of those two organizations, I welcome you here this afternoon. We expect this to be just our best event of the year, so thank you for being here. Before we start, I would like to thank the people who made this possible. The Department of Energy supports us and is our partner in these programs, and they do an unbelievable job, and they create a great resource that goes out to the Washington area and across the country. We have 200 phone lines, and we have had people on those phone lines from all around the world. We just couldn't do it without the Department of Energy, which is Pam Pontillo and Kathy Binder, and we just can't thank them enough for giving us this great resource, so thank you. Now, yes, thank you. Then I just want to bring your attention to what we're going to do next month. November, we're going to have a PhD in psychology, a person named Kibben Turner, who's going to talk to us about denial, deception, and distortion in the workplace. She's going to discuss psychological barriers to resolving conflicts. And we think in the ADR field that denial is one of our biggest problems, so we're hoping that'll be a really good event for us. So let me introduce to you the General Counsel for the Department of Energy. That's Scott Blake Harris, and he is working here. He was appointed here by President Obama. He's practiced law in our area for 34 years. He's received many honors over the course of his legal career, including the prestigious Marconi Bell Award from the National Association of Radio and Telecommunications Engineers, and he's received the Chairman's Award for Special Achievement at Federal Communications Commission. He's regularly ranked as one of the top lawyers, both in Washington, D.C. and nationally, and he graduated magna cum laude from Harvard Law School and Brown University, where he was a member of Phi Beta Kappa. So I'm going to turn over the program to him, and again, I just want to thank you for being here.
So I often get asked to introduce people, and I always say nice things, but I'm going to tell you the truth. I am very rarely awed by people I am asked to introduce. Today I am awed to introduce Ken Feinberg. I was trying to think of the event most closely associated with this in terms of how I feel about it, and those of you who know me know that my office is filled with signed baseballs. From the 1950s and 60s and 70s, because I was a great Yankee fan growing up, and that was my era. Don't nod at me and sneer at me, you Red Sox fans. But the thing that I recall most is that when I was 25, I got to meet Hank Aaron, right? And for me, it wasn't like meeting God, but it was close. So introducing Ken Feinberg is, for me, sort of like meeting Hank Aaron. This guy is unique. He has a reputation both in the legal community, in the government, outside the legal community, that is second to none. I asked folks to prepare a list of all of the important things he'd done, and no joke, this is actually true. It was like 4 pages long of bullet points of really important things he has done that were worth noting. And I decided not to read the 4 pages because by the time I was done, this program would be half over. So I'm going to only read the really, really important stuff that he's done, just to give you a sense of his career. As you all know, particularly those at the Department of Energy, he's been appointed by President Obama to administer the $20 billion escrow fund that has been set aside to pay the claims arising from the BP oil spill. You may also recall, because it wasn't that long ago, that he was the pay-czar, as they called him popularly at least, for the Troubled Asset Relief Program when he handled the Executive Compensation Fund. There was another easy task to handle. He served as Special Master for the September 11th Victims Compensation Fund. He handled the Memorial Fund following the tragic shootings at Virginia Tech. He was hired by a number of insurance companies to design, implement, and administer an ADR program arising out of Hurricane Katrina and other Gulf Coast storms. I mean, that's a career for 2 or 3 people right there. But he's also been a court-appointed special settlement master and mediator in thousands of other kinds of disputes, including figuring out the fair market value of the original Zapruder tape of the Kennedy assassination. Some of you were probably too young actually to understand the import of that, but that was another very, very big deal. And he was also one of 2 arbitrators selected to determine the allocation of legal fees in the Holocaust slave labor litigation. I mean, you know, even to describe these things is to lose your breath a little bit. Among the more ordinary, extraordinary things he's done, he was a law clerk to Chief Judge Stanley Feld in the New York State Court of Appeals. Again, folks of my age remember Judge Feld as one of the giants of the bar. He was an assistant U.S. attorney in the Southern District of New York, special counsel to the U.S. Senate Committee on the Judiciary, administrative assistant to Senator Ted Kennedy, a partner at Kay Scholer, designated Lawyer of the Year by the National Law Journal. I'm very proud. I usually get on these lists, you know, down number 750. You know, and that's great. We're talking number 1 here. He was listed in Profiles in Power, the 100 most influential lawyers in America, I don't know, every year going back to the 80s. And he's president in his spare time of the Washington National Opera. You don't normally get to meet folks of this stature, of this ability, and I'm just thrilled to be here today. Mr. Feinberg, please join us.
Wow, that's a great introduction from Scott, and I'm thrilled to be here. Now, the one thing Scott didn't mention in that list of achievements is he didn't mention my book that I wrote after my 9/11 victim compensation experience. This is a very interesting book. It's called What is Life Worth? The Unprecedented Effort to Compensate the Victims of 9/11. Public Affairs Press, 2005. Paperback or hardbound. Now, you may have trouble finding that book in Borders, Barnes & Noble. Don't worry. My personal supply of my book is virtually inexhaustible. And if anybody has trouble finding it, Scott will get me your name and I'll be glad to get you a copy. I really am very, very honored to be here today. I jumped at the chance when I got the invitation, jumped at the chance to spend a few minutes with the experts on ADR in the government. It isn't that often that I get a chance to pay tribute to the people in this audience who labor in the vineyard every day, out of the public eye for the most part, trying to advance the concept of alternative dispute resolution within and outside of the government. It is a challenge. And when I learned of the opportunity to spend a few minutes with the experts, to share stories, take questions, get answers, I immediately accepted, because what you do every day is very, very important. Now, I may be involved in some very high-profile mediations and disputes like BP and 9/11 and Virginia Tech, but it is just the tip. Qualitatively, everybody reads about these cases, but what you're trying to accomplish by getting the government to be an ADR participant, very tough, not easy. I find the government, with great reluctance sometimes, is willing to relinquish a great portion of the leverage that it has to come to the mediation or the arbitration table. And when the government does come to the mediation table, I find it extremely helpful if you're there representing the government in trying to get to yes in terms of disputes. I have on my desk right now one major effort involving the Army Corps of Engineers in trying to move mediation forward. It's not easy. We shall see. But I have allies here working within and without. Not only in that case, but in hundreds of other cases. So that's sort of a little bit of the context that brings me here today to sort of pay tribute to what you guys are doing, frankly. Now, Scott's right. I mean, there have been some fascinating cases I've been involved in, and the ones that he mentions are, yes, complex disputes. Complex disputes. But all of them offer variations on the traditional notion of mediation. Now, I start off with this principle. Is there a common denominator in all of these complex cases that I've worked on? Is there some bedrock principle from 30,000 feet that sort of defines them all? And the answer is yes. I've found over the last 25 years that there is a very small group of cases which are so unique and so unprecedented that the conventional, traditional way of dispute resolution won't work. Or policymakers believe there's got to be a better creative alternative. In thousands of cases where you and I, when we have mediated, that's one thing. But in the ones that Scott mentions, somebody has made a decision up front. There's got to be a better way. We can't simply go to court or fight a battle which ought to be resolved more efficiently and more effectively. It started with Agent Orange, you see. In 1984, when Judge Jack Weinstein in federal court in Brooklyn decided that the Agent Orange case involving Vietnam veterans who had been exposed to the herbicide Agent Orange while serving in Vietnam, that case had been kicking around for 7 years. Judge Weinstein decided we better bring in a mediator to try and resolve the litigation 6 weeks before trial. And he asked me to mediate. Now, you know all the time people say, well, a mediator has to be sort of optimistic and upbeat. I'll give you a good example of an optimistic, upbeat mediator. I met the first day of the mediation around a table with the parties. First, we had the lawyers representing the Vietnam veterans class. Lawyers, how much do you want to settle this thing? $1.2 billion. 8 chemical companies, Dow, Monsanto, Hercules. How much are you willing to pay to settle this? Collectively, $25,000. I said, all right, we're making progress. We're closing the gap. We're starting to close the gap. Let's keep going. 6 weeks later, $180 million settled the case. Now, the government took a pass. The Defense Department, we're not going to mediate. We have sovereign immunity. We've got defenses. We're not going to come to the mediation table. Now, in that case, the government was dismissed by the court. So we settled the case through mediation in 6 weeks, a case that had been kicking around for 7 years. That lit up a light, not only among government employees, but among private individuals around businesses around the country. To me, Agent Orange was sort of the the jumping off point where you could tailor mediation to resolve complex, protracted disputes. Now, 9/11 was different, but there were mediation skills involved in 9/11. You see, 9/11, a statute was passed by Congress 11 days after the attacks. And the statute simply said, anybody who voluntarily wants to give up their right to litigate against the World Trade Center, the airlines, Boeing, the security guard companies, Massport, the Port Authority of New York, the FAA, anybody who wants to surrender that right can come into a no-fault administrative dispute resolution system, get their claim resolved tax-free. Attorney General Ashcroft asked me to do it. And over 33 months, we resolved voluntarily 97% of the claims. Only 94 people out of 3,000 decided to sue for the loss of a loved one on 9/11. Everybody else became convinced that they should enter this no-fault fund. And we paid, on average, for a death claim, $2 million tax-free. For a physical injury claim, $400,000 tax-free. We corralled virtually all of the cases. Now, what we learned in we learned some fascinating lessons about the 9/11 victims, which you guys know all about. First, you're dealing with very, very emotional people, victims, who lost loved ones on 9/11. They said goodbye to loved ones after breakfast and never saw them again, incinerated at the World Trade Center on the airplanes, at the Pentagon. So you're dealing not so much with reasonable calculations of loss, economic loss, non-economic loss, projected work-life calculations. What would this person have earned over a lifetime? You're dealing, as you know every day, with people who are emotional, distraught, angry, frustrated. How do you deal with that? Well, one way you deal with it is to confront it. Everybody who came into the 9/11 Victim Compensation Fund was permitted to have a private, confidential hearing under oath, an opportunity to be heard, to vent. And did they ever? Did they ever? Nobody came to see me to discuss the money. People came with medals, diplomas, certificates of good conduct, photographs, autograph albums, films, audio tapes. Lady comes into me, Mr. Feinberg, I lost my husband at the World Trade Center. We were married for 25 years. I'm here. Thank you for the hearing. I'd like to show you a video of our wedding. I want you to show what those murderers did. I want you to see. And she showed the video of her wedding. There's my uncle, and that was his sister, and thank you very much. I appreciate the opportunity to come in here. Man comes in and says, I lost my wife. She was an angel. I want to play you the audio tape of her calling me to say goodbye, trapped in the World Trade Center. I want you to hear what those murderers did. Screaming, and here's where the safe deposit box key is, and say goodbye to our loved ones. Now, that's not traditional mediation, but you better be there to listen. You better be there to empathize, and you better not say the wrong thing like I did a couple of times. I made the mistake. I learned. Don't meet a woman who lost her husband at the World Trade Center and say, I know how you feel. You don't know how she feels. And she resented that, saying, Mr. Feinberg, with all due respect, you have no idea how I feel. And the mediator's skills in listening, in urging some degree of closure, talking about these issues, my mediator skills helped. Now, a degree in divinity school would have helped with 9/11, but it helped. In effect, you're a neutral trying to convince a client to come into a fund that will get him or her prompt payment without the necessity of lengthy, uncertain, costly litigation. That was the 9/11 fund. Virginia Tech, similarly, the same effort to get 32 families who lost loved ones in the shootings to accept a gift, to accept the money and take it. The problem with Virginia Tech was this. There's 32 dead. We've got $8 million to distribute. And there are physical injury claims and mental anguish claims. 32 dead. Families, I'm going to give everybody, unlike 9/11, which I couldn't do, I'm going to give everybody the same amount, $212,000 each. One lady comes to see me. Not fair. Your design is flawed. Why are you giving everybody the same amount of money? There's 31 dead. They were students. They weren't earning anything. They were going to school. My husband was a professor, a wage earner. Like 9/11, surely you're going to give economic loss and work life and wage loss more money than 31 other students who were on scholarship and weren't working. So I want double what the others get. No, I said, all life, in this program, all life will be deemed the same in value. The 32 are all dead. I am not going to make distinctions based on work life and jobs and a revenue earned. Too hurtful. I'm giving everybody the same. All life is equal in this program. Tough decisions. I decided that was the right thing to do in that case. Then we had students in Virginia Tech who were never in the building but watched everything from across the street in the dorm. Mental anguish, they're suffering, they're getting depression, they're getting clinical help from Virginia Tech Hospital. Mr. Feinberg, we want money because of our mental suffering. No, not enough money. But I'll make one exception in the design of the program. No mental suffering will be paid cash. But if your mental suffering is the direct result of your being part of the carnage in that classroom, escaping through mere fortuity. One lady came to see me. She said, I was a student. The fellow to my left got his brains blown out in my presence. The fellow to my right got his brains blown out. And then the gunman turned on me and fired, and the chamber was empty. Click! Or I would have been dead. While he was reloading, I jumped out the window. Now I can't. I shake. We paid her. Mental anguish confined to the classroom. Judgment call. Judgment call. Pesar, first of all, I don't like that term. That term, pesar, makes it sound, first of all, my grandmother in Lithuania would be very surprised. She wouldn't know what to do, make of it. Pesar. She'd be very confused. But beyond that, pesar makes it sound like I had the job of imposing pay restrictions in some sort of imperial, arbitrary fashion. Not so. The pay calculations that we made, first of all, were pursuant to statute. I followed the statutory directive. And secondly, in making those determinations, although I ultimately had the authority to make those determinations, I did so only after consulting, negotiating with the companies themselves. Far from being some sort of imperial edict, we at Treasury in that matter bent over backwards to get consensus on what the pay restrictions should be and how they should be imposed. I ultimately had the authority. It wasn't a conventional mediation where it's non-binding. I mean, under the statute, eventually I make the decision. But only after a tremendous amount of back and forth. Mr. Feinberg, we're here representing Citigroup. If you don't pay amounts to our key people that we have submitted to you, they're going to leave. They're going to go to the competition. And you know, they're not going to go across the street. They'll leave and they'll go to China. Everybody's going to China to work. If you don't pay us enough, they're all going to disappear and they're going to go to China, or they're going to go to Europe, or they're going to go to work for foreign companies at a disadvantage. And this American company will be at a disadvantage. And the taxpayer may never get its money back. So you better pay us what we want. We refused. Instead, we sat down, and in each case, we worked out a pay package. The amount and the terms. Now, there's two interesting things I learned about the pay czar role. First, I would have thought that taking on that assignment, I would have incurred a great deal of criticism. Setting pay for private companies is none of the government's business. I would have thought I would have heard a lot about that. No such criticism. None. The main reason, I think, is because as to the very limited number of companies I was dealing with, 7, Citigroup, Bank of America, AIG, Chrysler Financial, GM, and GMAC. That's all. As to those 7 companies, the only reason they were in existence is because the government bailed them out. And since the government bailed them out and they owed the taxpayers the money, the attitude seemed to be, hey, the government represents the American people as creditors of these companies. And the government has every right to intervene when it comes to pay and to work this out, because after all, but for the government and the taxpayer, these companies would be in the tank. So the attitude seemed to be among the American people and among virtually all our public officials, Ken, go ahead. You're a creditor. Now don't expand your authority. Don't go beyond these 7. But as to these 7 companies, they only have themselves to blame. Go right ahead and set the pay. I also thought, when I took on that assignment, that there'd be very, very little interest in my calculations, considering that I was only setting the pay for 175 people, the top 25 officials in each of the 7 companies. I was very wrong about that. There was a tremendous amount of national and international interest in what I was doing, even for that limited number of people. It was a sideshow, really. There's only 175 people. I'm not setting pay for everybody in the government. I'm set for just a few people in 7 companies. Why the interest? Well, what I learned is there's a lot of interest, especially when the economy is going south and unemployment's so high, and there's populist fervor sweeping the country. People are very interested in what is Feinberg going to say that CFO is worth, that CEO, that vice president of human resources. 1 million, 5 million, 9 million, 800,000, 300,000. The fact that I was doing the unprecedented job of actually calculating the dollars that everybody was going to make, instead of just issuing vanilla prescriptions about pay. Pay shall be based on performance. Duh. Pay shall be long-term. Pay shall not be guaranteed. Nope, now let's translate that. You will make X. Oh, that was a great deal of interest. Great deal of interest. And we found some fascinating things doing that work. The top 3 people at Citigroup got more money than all 25 at GM. Tells you a little bit something about the skewed nature of Wall Street. But again, it wasn't a traditional mediation. And yet, as you know, mediation skills brought to bear to implement a statutory directive. And it worked. Now remember, under that statute, as soon as you repay the taxpayer, you're out from under Treasury's jurisdiction. After 1 year, Citigroup and Bank of America borrowed money to get out from under my jurisdiction. But you repaid the taxpayer, you're gone. And now there is BP. Now, BP is not a statutory directive. BP claims is a private process entered into between the administration and BP to set up and establish an independent claims facility to evaluate and process claims. And that's what I'm doing in the Gulf. Today, we've processed about, in 6 weeks, 55,000 claims, businesses and individuals, and paid out over $1 billion. We've made mid-course corrections in the program designed to respond to Gulf Coast public citizen criticism. It's taken too long. The checks aren't generous enough. We don't know where our claim stands. We can't get reasons as to why we got what we got. We're dealing with those problems. And now, day before yesterday, I announced a new decision. It's a fascinating problem. The problem is easy to articulate. How close do you have to be to the Gulf, near this oil, to be eligible to be compensated? You know, it's one thing if you're a motel on the beach in Pensacola and the oil washes up and you say, my guest rate has dropped 40% because of the oil. Pay me. Easy case. But what if you're a hotel 300 miles from the beach or the Gulf where the oil was? Mr. Feinberg, look, I agree there's no oil anywhere near here. Nevertheless, the perception among tourism was that the oil might arrive tomorrow. And look, before the spill, occupancy rate, 70%. After the spill, occupancy rate, 30%. Pay me. Well, now, wait a minute. You're 300 miles from the oil. So what? Before the spill, after the spill. Here's my data. Pay me. So, A, should such companies, such individuals far from the spill be eligible to have their claim processed? I said yes. I'm not sure that's the law, but I said yes. But the further you are from the spill, can you calculate and offer up your damages caused by the spill? You know, it's one thing if you have a canceled contract to show me. What if it's just perception? People thought the oil might get here. I mean, the BP program, like the 9/11 program, like Virginia Tech, highlights some of these mediation skills that are so essential. You know what they are: doggedness, commitment, competence, knowledge of the claim, flexibility, the willingness to do mid-course corrections in your strategy in order to get to yes, creativity. Let's look for an innovative solution to an otherwise intractable problem. I mean, optimism, the belief that people who are engaged in a process want it to work. What I find so interesting, among many things, about mediation is when you get people to sit down at the mediation table, no matter how skeptical they may be about the process when you start, by the end of the process, they have a vested interest in securing a yes result. Very often. Very often. How you nurture that skepticism, how you get people to have faith in the system, is a challenge. It's a challenge. Now, when the government is at the table in a mediation, it's not your ordinary private party mediation. There are other variables in play, I find, when the government is mediating. Some help to get a resolution. Some are a challenge to get a resolution. One thing I've learned about government mediation: the government does not like to surrender the leverage it has in dealing with a private adversary. It's a problem. The government is the government. And it doesn't come up so much during the mediation. But in my experience, it's very often a problem in getting the government to mediate at all, because of the view that the very willingness to mediate challenges a certain degree of the government's high road position relative to a private claimant or a private party. Secondly, some of the mediators' efforts to get the parties to narrow their differences don't really work as well with the government. Private parties, it's going to cost you a fortune to continue to litigate. The government isn't so much concerned about the cost, in my experience, as the glut on government time. It's not just the dollars that the government is concerned about. It's also, in my experience, we don't have the resources to divert, to litigate this thing for years and years and years. That's always been the EEOC's position with me, that one reason the EEOC wants to mediate is a desire to get closure, clear up some of the backlog without the diversion of limited resources to litigate. Now, I usually find government lawyers in mediation to be better prepared and be more knowledgeable than lawyers in the private sector. Government lawyers know their stuff. They're not always flexible. they're not always willing to budge. One problem with government mediation, I find, is the issue of authority. It's very important when you mediate that the people at the table have authority to resolve the dispute. I find in many cases involving the government, the people at the table for the government have authority only up to a very limited point, and then after that, we'll be back to you. We'll be back to you. And some of the efficiency associated with prompt mediation goes by the boards. So I try, when the government's in mediation, to get the government to send the right people with authority to get it done. Because once you leave a mediation, if you started here, and after a day or two of mediation, you're here, but you can't get it done, so we'll adjourn, well, the next day you're back to here. Rarely do you get rarely does the momentum continue to get us to yes. That's why I usually urge the parties to stay late and not leave without a deal, because of my experience that it's going to unravel the progress you've made if you adjourn. Now, here are some of the issues that I see that come up all the time in these mediations. Who's the mediator? What type of mediator do you want? Do you want the aggressive, interventionist mediator who's going to evaluate the merits and, as the neutral, give you his or her considered opinion? Or do you want a more passive facilitator who isn't expected to offer her or his personal views of the merits? Critically important issue, the type of mediator you want. Second, who's at the table? The government wants the right people there from the other side wants the right people there with authority to settle the dispute. If you don't have authority, it becomes a real problem. 3, how do you go about mediating? Now, I find I've tried all different ways of mediating. The one that seems to work the best is phase 1, get the mediator in advance a written submission of your position. Confidential, not shared with the other side. Ken, here's what we're really thinking. Just so you'll know, before you come to the mediation, here's sort of where we're coming from. Here's the facts, here's the law, here's our settlement proposal, here's basically how we ought to get this done. Phase 2, around the table, a joint mediation session. Private party, tell the government your position. Government, tell them your position. Not the lawyers, let the principals hear what's going on here. Phase 3, separate rooms, shuttle diplomacy. I want to be the only person going back and forth controlling the information flow. You know how important that is. Private party. We're never going to get anywhere with the government. This is all a waste of time. Now I go see the government. We're making progress. They're interested here. They're loosening up here. Government. These guys, they're lucky they haven't been indicted. We could stay here till tomorrow. It'll never get done. Private party. Government's willing to be bend here. Going to be flexible. And you try through information flow to sort of move the parties slowly towards a resolution. I find one-day mediations are virtually, in my business, ineffectual. 2 days, maybe 3, contiguous. Now, that has something to do with the size and dynamic of the case. But those are some of my general thoughts about mediation involving the government, some of my anecdotal experiences, where although they may not have been traditional mediations, mediation characteristics and skill really came in handy. I mean, you got to be a shrink in this business. You know this. You have to be a psychiatrist. And you confront, in these complex cases, real difficult barriers to getting people and companies to see beyond their parochial concerns about a matter. More often than not, we're successful, but it takes a lot of work. So I wanted to reserve about a half hour for questions. That was the great attraction coming here. I was promised that this would be a rather sophisticated audience that would pose questions or offer suggestions that I might use. And I think that I'd be crazy not to take advantage of this sophisticated crowd. So why don't we have some questions now?
Looking for hands?
Oh, come on. Yes.
Good afternoon, Mr. Feinberg. Tony Palladino from the FAA's Office of Dispute Resolution. Question on problems of getting people with authority to the table or in the room. Under what circumstances and how do you decide whether to go forward if you have that problem and it seems to be intractable? What are the sort of considerations on how you proceed if you reach sort of an impasse at that point?
First, I try not to reach an impasse before we even come to the table. Mr. Company A, who are you sending? We're sending this person and that person. Government, what do you think about who they're sending? No, we don't think we'll get anywhere. He caused the problem. Why is he coming? We want people with authority with an independent view. You go back to the company. Look, it doesn't matter that you think they have authority. Your adversary doesn't think you have authority. So if we're not going to, I'm not saying that we won't get it done, but if you don't send people that the other side thinks have authority, we're behind the eight ball before we start. Now, I rarely let that be an obstacle to even meeting, because once you meet, you start generating some settlement momentum. But I do try as best I can to intervene and try and make sure before we show up blind that each side is comfortable with the people on the other side. And usually I weigh in and get people to send different people. But if not, we'll go forward. And then we use it against them, you see. That's what I say. Let's say the government says, you know, they're not sending the right people. Good. When there's an offer and it's ridiculous or a demand, and you'll remind them that, oh, this is hopeless. You sent the wrong people. Use it to your advantage as a negotiating ploy. No wonder they're not doing the right thing. We told you. We told you they weren't sending the right people. That's not bad. It's not bad. So one way or another, we'll get to yes.
I have a question from the phone, one of the phone lines. What factor does the reputation of the mediator have in conducting the outcome of the mediation?
Oh, the reputation of the mediator, I think, is important. That's why it's so hard to break into this business. Especially if you're going to be a mediator who evaluates the merits. I mean, I find that an experienced mediator with a track record comes to the table with some real credibility in getting things done. I think you guys ought to offer another $2 million. It's just too low what you're offering. Well, I'm just telling you, you can do it any way you want. I've been through these things. I'm just telling you, if you want to get this done, well, all right, if you think so. You know, I mean, I think credibility and reputation is important. And I find that I'm asked all the time, you know, I want to get into mediation. Well, if you want to get into mediation, I mean, that's fine, and you should get into mediation. but get some experience, get some a reputation for being in mediation. You know, I see this, you guys see this, these sometimes ex-federal judges decide they want to mediate. Judge, when you have the robe on, or you're an arbitrator rendering final decisions, that's fine. But a mediator, just because you're an ex-federal judge, I mean, you're trying to cajole and encourage people to settle. I don't find many ex-federal judges that are effective mediators. There are some, not many. That's not where their reputation lies. So it's an acquired skill, and the more experience you have, the more credibility you have, and the more people will listen to you, and the easier it is to get to yes. Yeah, I find that to be the case. Yes, ma'am.
You mentioned the written submissions, and you also mentioned something about being a psychiatrist.
Yeah, I go all over the lot.
I'm wondering how, this is pre-mediation or getting people to consider coming into the process. How do you help, what do you talk about with people to sort of get them out of the litigation mindset into this is going to be a little bit of a different conversation or a different experience, and help them kind of come in a little differently so it'll be more effective for them?
Well, that's a great question. How do you get people to mediate effectively? Well, that could be a whole chapter in our book. First, you try and explain to people the alternative if they don't mediate. You're rolling the dice, and it's going to cost you a fortune, and who knows what's going to happen. Why don't you control your own destiny? Second, you want to have the right people there. I find that if I just go to the lawyers representing the client, that's tough. Nothing wrong with that. The lawyers don't understand. They're trained to be warriors. They're not trained to see the wisdom of mediation. Plus, it impacts their budget in some respects. You know? Third, getting the government to mediate is not always that easy. I don't know. We don't usually need a third party. We do our own negotiating from strength. Yeah, well, here are the alternatives. I try and find the right person in the government or in the corporation. The right person with the vision and the strategic flexibility to see the wisdom of a non-binding alternative. Hey, if it doesn't work, so then you'll go back and litigate for 10 years. But you're right. I mean, one of the challenges of an effective mediator is to try and get the parties to even come to do it. Now, sometimes I get instructions from one side. You call the other side and tell them we want to mediate if they will. Now, that's great. Because then I can call up the other side and go, look, guys, let's be reasonable. I'm calling specifically at the suggestion of the other side. Obviously, they want to get this done. Otherwise, they would have never offered me up. I mean, sign of weakness? They're willing for me to tell you they want to mediate. Let's go. That helps. That doesn't happen very often. Usually, in mediation, both sides come to me, or the judge does. Let's mediate. But how you get people to the table is not easy. You're right. Yes, sir. Well, there are a couple here.
One of the theories I've had over the years is that agencies often don't realize the cost of litigation. They have kind of the view that, well, we don't know if we can win this or not. We think we can. Send it to justice. And justice picks up the tab. If the agencies had to pick up the tab for that justice lawyer, then they might realize more what it costs. But there is what I found to be sort of one shining cloud, and that's the judgment fund, EJA. If we lose, their lawyers get attorney's fees, and they will come out of our programs office, a fact that most of our program offices don't know. In fact, I'm not even sure that some of our lawyers know that when they're sort of pushing litigation. And it comes as a real shock to pay $150,000, $200,000 worth of fees. But it seems like a very strange system to encourage efficiency. and, you know, get your view on it.
Well, agencies differ too. I mean, I've found that the dollars and cents associated with ongoing litigation my experience doesn't get me too far with the government. What does get me make progress with the government is the diversion of resources. The time, not the cost. We have a limited number of people here, and the time these people will have to devote to this matter. Now, you know, cases that go to the Justice Department, I'd like to think that DOJ, I don't know this, but I'd like to think that DOJ is rather a strong proponent of ADR. In my experience, they have Peter Steenland and others in the past were pretty good in urging me to help them get rid of some dog cases in terms of age. But I think that your point is agency to agency, and this notion that it's not just the money, it's the diversion of expertise into this case that is helpful in trying to get mediation off the ground. Yes, ma'am.
Let me just lay in the second. Can we just make a second?
I was wondering in the Gulf oil spill effort, how
I'm sorry?
I was wondering in the Gulf oil spill effort, how the claims are actually processed. Is it through claims examiners, and if there's a dispute, are mediators brought in, or the claims examiners serve as mediators, or how does that mechanism work?
No mediation. Claimant files a claim either with 35 BP offices along the Gulf Coast, now Gulf Coast Claims Facility, BP's out of it. 35 offices that were set up by BP, now they've been assumed by my office. Or they can file online, never go to an office, or by fax, never go to an office. That claim will then be processed. It'll be, the intake is in the Gulf. The claim will then be processed at a central facility where the calculations are made pursuant to the methodologies we've been using for shrimpers, for oyster harvesters, for fishermen, for hotels, for motels, for businesses along the Gulf. And the recommendations then come to my office in Washington, where we want to be assured of consistency. But there are no hearings. There are no formal hearings like we had in 9/11. There's 116,000 claims so far. We'll either pay the claim, send back a notice of deficiency. You haven't backed up your claim with any backup. You say you want $30,000 and you attach your fishing license. Where'd the $30,000 come from? I mean, it's a problem down there with deficiency of documentation. We've paid 55,000 claims. There's probably 30,000 that are deficient in addition. So that's how the process works. It works pretty well now. We got off to a slow start. But I think now we're pretty much up to speed, current, in terms of the number of claims. There may be some isolated claims that we're sitting on that are eligible. But we're current, very generous, I suspect, based on the $1 billion that's gone out. And we shall see. But I think it's working fairly well.
Hi, thank you. So I have a question. One of the things that I've kind of
Wait, I can't even see you. Where are
Hi.
you? Oh, okay, yes.
One of the questions that I learned in a class at the School of Natural Resources on mediation is that there are some cases that still do belong in the courts, and those are generally cases of principle. And I'm wondering your thoughts on that overall statement, and just to get a sense of what cases you think do belong in front of a judge, and based on your experiences, what you would say to that.
There are very few cases that I've seen that aren't eligible for mediation. Very few. There may be some, way back when, tobacco. was probably not eligible for mediation at the time because the companies felt that if they settled one case, they might as well give the keys to the company to the plaintiff's bar. I'm not sure that's right. It certainly didn't prove to be right. There may be a few cases where you need a judicial imprimatur and a formal finding of a court because of the precedential importance of the case. The other question I get all the time is, well, even if a case is eligible for mediation, what's the optimum time to mediate? I find usually the earlier the better to mediate. The longer the case drags on, everybody gets their back up. Depositions, you call that guy a rat, you know, and before you know it, people get emotionally charged. They don't want to settle it. I'll teach that guy. I mean, so I think the earlier, and it saves time and money if you do it earlier. Now, the lawyers get nervous. We don't know enough. I hear that all the time. We don't know enough. We got to wait another year. The fact of the matter is, you use that argument, we don't know enough, you try and use it to your advantage. I want $8 million. Oh, no, we're only paying $1 because what? I don't know enough to only, if you showed me all the facts at $1 million, maybe that's what it's worth. But if you want me to mediate now on the basis of this record, I'm making certain assumptions and I want $8 million. Now, you want to mediate, and you say that it's only a $1 million case, but I think I'll be able to show after a year of litigation, maybe it's a $30 million case. I'll take $8 million now to be gone with it. So you try and use the absence of a full record to your advantage in mediation. But I must say, I haven't seen many cases that we couldn't work out if we could sit down across the table with a mediator and try and get them done. Yes, sir.
Say you didn't get the timing done well. Pass the mic in, please. It'll help the people on the phone.
Say you did not get the timing right, and the mediation does not start toward the beginning of the dispute, and let's say, in fact, the dispute goes on for, I don't know, a decade. And so emotions are pretty high at this point. In fact, you have emotions, it really is an emotional situation where your opponent really feels like it wants to have the head of a government employee on a stake outside the building. How do you get to a settlement at that point? How do you take away the emotion, and how do you bring it in?
That's where you got to be a shrink. That's where you sit down with that person who wants the government employee on a stake and you read her or him the Riot Act as the mediator. Look, you're never going to get that government employee on a stake. And if you do get her on a stake, it's going to be 8 years from now. Let's get a solution now. I'll work with you to get the job done now. And that's the part of mediation where a skilled mediator deals with the emotional response of an adversary who is unreasonable. And you try and bring that adversary back to some degree of reason. Now, the way you do that varies from case to case. I've seen EEOC cases where a discriminated against plaintiff, you say going into the mediation, it's hopeless. Then I sit with her and I get the company to apologize. Mrs. Jones, we know you're angry. You got laid off. Allegations of age discrimination. We want you to know I am here as the Vice President of Human Resources of this company to tell you we are sorry. You worked for 31 years for this company, and it came to this. You don't know, and here's a letter from the CEO. We'd like to give you a watch. and we're sorry. Now, here's also a check. But we are sorry Ooh. In discrimination cases, sorry goes a long way. Now, getting the company to admit sorry, you know, but goes a long way. Getting into the confidence of the disgruntled claimant, that's a challenge for the mediator. Combination of carrots and sticks.
I work for a small government agency that has
There's no such thing.
that has independent litigating authority. We're enforcement and regulatory. And we mediate some cases, but we find that we have many of the problems that you've identified because our upper level has to authorize every settlement. There goes a whole lot of flexibility and creativity. And we also, therefore, can't send someone with authority to settle. Because of programmatic issues as well, there's just very little leeway. Now, sometimes we're ordered into court and we mediate, but there's a question of when we're not ordered into court, whether it even makes sense for, given our limitations, to think about mediating. Do you have any thoughts about whether there are particular characteristics of a case that might, even within that framework, that might lend itself to mediation?
Yeah, you might lose. But I'll tell you the best weapon you've got in a situation like that, I think, is to focus on those disputes that are relatively getting ready for trial. If you go down the inventory of your cases where you've got very little room to maneuver, and there's a trial date looming 3, 4, 5 months away, not years or no trial date yet. No trial date in a situation like you confront is largely, not exclusively, largely hopeless. But if you've got a narrow time frame so that you can not only tell your principles about the importance of not rolling the dice in the courtroom, but convincing the other side, look, trial is a few months away. This is our only shot, a window of opportunity. We don't have a lot of room to maneuver. So this is sort of like it. Maximum opportunity. Now, of course, the closer you get to trial, the more the other side's saying, we've waited all this time for a trial date. We don't care what your limited authority is. We're ready to go to court now. So, but I think that in dealing with your own internal problem, that's one thing to look at. The other possibility is to try and convince people in your shop that even though you've only got a narrow range of flexibility, let's take advantage of it. We can probably, you might do something like this. I've seen this with insurance companies. Look, we've got 323 litigations pending in our little shop. I'm making this up, of course. 206 of them. Let's just try and, spend 6 months resolving these cases. Why are we spending all of this time and energy with these 323? Let's at least sort of put it on the radar screen and prioritize it over a relative window to try bing, 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 line them up. Let's try and get rid of these cases based on some type of formulaic red light, we can't mediate. Yellow light, maybe we can mediate. Green light, no reason we shouldn't mediate. And take a rather systematic approach to seeing how many you can clear out. Easy for me to say, I don't even know what agency, but something like that. Something like that. 2 more? Let's go. 2 more questions.
Thank you. Mr. Feinberg, I just want to ask you if you could share with us one of your most profound or surprising mediating moments, and what effect did it have on you?
I'll tell you the most horrifying, not horrifying, that's the wrong word, the most difficult moment I think I've ever faced in mediation. And it wasn't really a mediation. 9/11. In comes a 24-year-old woman to see me, sobbing, almost her composure. I was worried she was going to faint, sobbing. Mr. Feinberg, I lost my husband at the World Trade Center. He was a fireman. And he left me with our 3 kids, 6, 4, and 2. He was Mr. Mom. Every day that he wasn't at that firehouse, he was home, teaching the 6-year-old how to play baseball, teaching the 4-year-old how to read, reading a bedtime story to the 2-year-old. And what a cook! He cooked all our meals. He was the gardener around the house. My best friend. Mr. Feinberg, the only reason I haven't jumped out a window and killed myself is because of the 3 children. And I don't care about the money. I really don't. I'm just here to tell you about my husband and how my life is over. I will never remarry. I will never, ever be the same person. Thank you. She leaves. The next day, I get a telephone call from a lawyer in Queens. Mr. Feinberg, did you meet yesterday with Mrs. Jones? Yeah? And the 3 kids, 6, 4, and 2? Uh-huh. Mr. Mom? Uh-huh. Now look, I'm not trying to cause you any trouble. I'm really not. She doesn't know that Mr. Mom has 2 other kids by his girlfriend in Queens, 5 and 3. And I'm telling you this because when you cut your 9/11 check, there's not 3 surviving children, there's 5. But I'm sure you'll do the right thing. Click. Now you ask yourself, do you tell this lady about these 2 other children? About her husband's double life? Now, this was 8 years ago. I'm sure she knows by now. I didn't tell her. But I was up at 3 a.m., I'll tell you, on this one. She's sobbing about her husband. Should I tell her, look, lady, there's 2 other kids? We went around and around, our staff on this. I decided not to tell her. Not my place. I'm a federal bureaucrat trying to get the money out. I don't know the facts. I don't know the circumstances. I'm not a family counselor. I just want the money out the door. We cut 1 check to her and the 3 kids, and we cut a 2nd check to the girlfriend as guardian of the 2 kids. And that was it. But you ask me, did I ever experience a situation where I sort of stopped dead in my tracks? When that lawyer called me from Queens, I just walked around the block on that one. I mean, what do you do? I'm not Solomon. That's what we decided to do. But that one I'll always remember. Last question. Yes, sir.
Thank you, sir. I want to respond to a point you were making earlier when you said it's very important for the parties in mediation to decide whether they want more of an evaluative approach or more of a facilitative approach to mediation. And when I heard that, I thought, well, maybe they should tell the mediator what kind of orientation they want. But the main question is, if you were giving advice, are there certain circumstantial elements that you think would lend more to facilitative or evaluative kind of approach to mediation?
Well, I guess, I mean, you guys know, I mean, I'm rarely called merely to facilitate. It's not exactly my personality. I think that if you got a protracted, complex litigation where the neutral evaluation of a credible mediator will help the parties reevaluate their own risk, very, very helpful. However, the government may have cases where it doesn't really want to abdicate the responsibility of evaluation to a neutral. The government may say, look, frankly, we don't care what the neutral thinks. We've got a view, we've got the expertise, and we're reluctant to be the recipient of a neutral view which will also go to the other side. It's a very delicate question. I find that one reason the government doesn't use me more often than they do is because of that. Ken, we frankly don't want you telling us and the other side about the risks to our case. We'd rather deal directly either with the other side or with the facilitator who will encourage the parties to get to yes but won't offer an opinion. You got to evaluate each case and decide that. Once again, I want to thank Scott, DOE, all of you. I don't get enough of an opportunity to sit with my colleagues like you who do this stuff and exchange these types of dialogues. I think what you're doing is fabulous, fabulous. And you're up against some real challenges. You know, people ask me all the time, the future of ADR. The ADR has a future. It really does. Anybody who thinks that alternative dispute resolution is going to replace the litigation system in this country is dreaming. The litigation system in this country is so ingrained in the history of the country, in the fabric of our society. It's not going to change. But ADR does have a role to play. I think that what you have to deal with are challenges that are much more complex and difficult than private parties when it comes to ADR. But every indication I have is that slowly but surely, you guys make progress and are doing and waging the good fight. So I want to thank you all for being here or on the phone or listening. I am an ally and a fellow colleague of yours. I think what you're doing is fabulous. And I want to come here today to thank you for advancing the cause. So thank you very much.
So, Mr. Feinberg, I just want to thank you so very much. You are an inspiration to us, both personally and professionally, and we just can't thank you enough. So thank you.